interesting. And also the disciplinary action, the intention is also disciplinary action should be taken into consideration that give us idea how the IP or IP entity has to behave or not to do certain acts or not to take certain action. And the care and precaution to be taken care by this. As we discuss, it remains in our mind, and it's gets stored that how we have to behave. With that intention, we are trying to start that series, and this is our second session in this, and we'll keep on doing bi-monthly the same thing. Thanks for all your support. Today we have with us Mr. Devang Thakar, Company Secretary and IP and Register Valuer with us. Welcome, Mr. Devang Thakar.
Good morning. Hello. Good evening.
Thanks for your time. Sorry, friends, Mr. Harish has Deputy Vice President Omkara ARC agreed, and he was supposed to join till morning. It was confirmed, but suddenly he has to leave for some urgent work as his colleague got sick and he expressed his inability. So at last moment, honestly, we have no choice, but we are conducting this webinar without any other panelists from the industry. So let me introduce formally Mr. Devang Thakar. Mr. Devang Thakar has over 30 years of extensive experience in field of finance, legal and corporate compliance. He is a member of ICSI. He is a practicing CS and also in the finance consultancy, IP and a registered valuer. As regards education, he is a BSc. He also has hold a diploma in system management and master's degree in financial management. He is IP registered with IBBI and ICSI IP. Welcome, Mr. Devang. Thanks for your time.
Well, thank you very much for being invited.
And we have with us Ms. Kantyayani Gaurav, Manager IBC Mehta and Mehta. She is presented today. Ms. Kantyayani, you can start your presentation. Thank you.
Thank you.
Thank you, ma'am. Good evening, everyone. Thank you for joining this webinar. This is organized by Mehta and Mehta. My name is Kantyayani Gaurav and I'll be your speaker today. Before we start, I would like to let you know that this webinar is going to be recorded and it's going to be available on our YouTube channel. Let's begin with the important judgments under the code. The first judgment is between Siddharth Sahib Singh versus Apex Council of Delhi and District Association. This was passed by Honorable High Court Delhi on 10 July 2023. In the present case, the petitioner has filed the present writ petition under Article 226 of the Constitution of India, challenging the notice issued by the Apex Council of DDCA for convening the extraordinary general meeting of the members of the DDCA. It is the petitioner's case that the resolution passed is invalid and it should be quashed and set aside. The respondent raised preliminary objection on the maintainability of the present writ petition. He submitted that the DDCA is a company incorporated under Section 8 of the Companies Act, and therefore the remedy for the petitioner is to move an appropriate application before the NCLT for redressal of its grievances. The court thus held that the petitioner has not made out a case that it is imperative for this court to entertain the present writ petition at this stage and grants liberty to the petitioner to approach NCLT for redressal of his grievances. Hence, the present writ petition is disposed of. The next judgment is between Asset Reconstruction Company India Limited versus Uniworth Textiles Limited. This was passed by the Honorable NCLAT on 10th July 2023. The present appeal has been filed under Section 61 of the Code against the impugned order passed by the NCLT Kolkata bench, whereby the application filed by the appellant under Section 7 of the Code against Uniworth was dismissed. The corporate debtor had initiated proceedings under SICA before the BIFR in 2004. The corporate debtor was declared as a non-performing asset on 31st August 2007. The proceedings continued till 2013 and were abated after the order was passed by the Appellate Authority for Industrial Financial Reconstruction. The appellant thereafter filed an application before the Debt Recovery Tribunal, and the same was allowed on 4 December 2018. Despite appellant's efforts, on 20th November 2018, the appellant issued a letter for revocation of the terms of the settlement due to non-compliance and thereafter filed an application under Section 7. However, the adjudicating authority dismissed the application on the ground of limitation. It is the case of the appellant that the adjudicating authority ignored the vital facts that the corporate debtor had acknowledged the outstanding debts and, in addition, acknowledgements in the balance sheets which extended the period of limitation under the Limitation Act. The counsel for the appellant further relied upon judgment in the matter of Gauri Prasad Goenka versus Punjab National Bank, in which it is clearly stated that the period of reference under SICA before the BIFR or the AAIFR would stand excluded while computing the period of limitation for the purpose of filing company petition under Section 7. Thus, NCLAT held that the adjudicating authority erred in rejecting the application filed under Section 7 by the appellant on the ground of limitation. Hence, this case is remanded back to the adjudicating authority to decide the case on merits of the application. The next case is Mrs. Tina Saraswat Pandey versus Regional Provident Fund Commissioner. This has been passed by Mumbai NCLT bench on 10th July 2023. The present application is filed by the applicant, who is the resolution professional, seeking directions to Regional Provident Fund Commissioner to remove lien and to release the amount which is held in its custody during CIRP. The company petition under Section 7 was admitted on 24th January 2020. The respondent herein had filed its claim, which were accepted. The respondent had passed multiple orders calling upon the corporate debtor to pay the outstanding dues. The RP had specifically taken permission of COC to operate the current account of the corporate debtor for the receipts and payments during CIRP period until the new current account was opened. The RP had communicated to the respondent about the initiation of CIRP and further informed that in order to meet the CIRP expenses, the bank account needs to be maintained by the RP, as all other signatories had to be suspended. However, the respondent, considering the corporate debtor to be a defaulter, froze the bank account. Thus, the court held that the RP is right in seeking lifting of lien created by the respondent on the ban account of the corporate debtor, as the purpose of Section 14, that is moratorium, is to ensure that no depletion of assets of the corporate debtor takes place during CIRP, and the corporate debtor is allowed to continue as a going concern. The next case is between Jaideep Ghosh versus Neeraj Agarwal, the RP of Castle Extrusion Private Limited. This has been passed by NCLAT New Delhi on 24th of July 2023. The present case has been filed before the Honorable NCLAT, challenging the impugned order wherein the adjudicating authority had approved resolution plan which has completely changed the nature of business. The court brought attention to Section 5, subsection 26 of IBC that permits a resolution plan that entails restructuring. Similarly, regulations 37A and B even permit for transfer of all or part of assets and also sale of all or part of assets of the corporate debtor. In the present case, the corporate debtor is not doing any business. Even the licenses had lapsed and not been renewed. The court gave its opinion that it was the commercial wisdom of the COC to accept the plan, which has been noticed by way of change of business of the corporate debtor. Also, it is a settled law that the acceptance of resolution plan is a commercial wisdom of the COC. Our next case is KCM Kumar versus Mr. Raghu Babu Gunthru, who's the RP of Spec Systems Limited. This has been passed by NCLT Hyderabad on 17th July 2023. In the present case, the RP invited resolution plans and the COC members were appraised about 3 resolution plans. However, while considering the plans, NCLT remanded the resolution plan back to the COC for further consideration. The applicant in the present matter is the director of the corporate debtor who runs an MSME unit by virtue of which he is eligible to submit a plan. Hence, he requested RP to grant him an opportunity to submit a plan which was rejected by the RP. The applicant submitted that the delay in seeking permission is that he has already submitted a resolution plan with another resolution applicant who has backed out from submitting the resolution plan. Hence, this delay. In this situation, the court relied upon Swiss ribbons, wherein it is clear that the code envisages maximization of value of assets. Further, as per NCLAT judgment in the matter of PLBB Products Private Limited versus Piyush Periwal, that the court is inclined to give an opportunity to the applicant who is an MSME to submit his resolution plan. However, the same would be placed by the RP before the COC for the same to be dealt in accordance with law. Our next case is by GP Captain Atul Jain, retired, versus Tripathi Hospital Private Limited. This has been passed by NCLAT New Delhi on 27th July 2023. In this matter, the adjudicating authority had dismissed the application filed under Section 7 of the IBC by the appellant. While dismissing the application, the adjudicating authority held that as the applicants failed to produce any document to show that the applicant has given money to the corporate debtor, the present case of the applicant cannot be considered as a financial debt. Hence, the applicant cannot be considered as a financial creditor either. Hence, the court held that the adjudicating authority did not commit any error in rejecting the Section 7 filed by the applicant. Our next case is Paschimachal Vidyut Vitran Nigam Limited versus Raman Ispat Private Limited and others. This has been passed by Supreme Court and the order dated is 17th July 2023. In a recent judgment, the Supreme Court held that Section 238 of the Code overrides the provisions of the Electricity Act 2003. In this matter, the appellant and the corporate debtor had entered into an agreement for the supply of electricity in the year 2010. Owing to the pending dues, the properties of the corporate debtor were attached to prevent alienation thereof. However, the corporate debtor became subject to liquidation since the resolution process under IBC was unsuccessful. Thereafter, an application was filed before the NCLT, and it was insisted by the liquidator that the attachment orders would dissuade buyers from purchasing the corporate debtor's property. This application was allowed by the NCLT, which directed the immediate release of attached property. The tribunal took this decision to ensure that the property was sold and the proceeds were distributed as per the provisions of IBC. This decision was then challenged before the NCLAT, but the appeal was also rejected. The court relied on judgment in Sundaresh Bhatt, who is the liquidator of APJ Shipyard versus Central Board of Indirect Taxes and Customs, wherein it was held that the recovery of dues through sale or confiscation could not be initiated once a moratorium was imposed under the IBC. To this extent, the provisions of the IBC were held to prevail over the Customs Act 1962. In the present case, the court referred to several other cases before finally concluding that Section 238 of the IBC overrides the provisions of the Electricity Act 2003. Accordingly, the court dismissed the appeal and directed the liquidator to decide upon the appellant's claim and complete the process within 10 weeks from the date of order. Do we have any questions for the judgments?
No, you can go ahead.
Do I continue?
Yeah, continue.
Now we'll be dealing with the orders passed by the Disciplinary Committee. In the first matter, the first contravention is charging of fee for verification of claims. The IP had been charging fees for verification of claims in addition to the professional fees being charged by him to act as an IRP or RP in the instant matter. The IP is duty bound to verify and collate claims as per the code. However, charging fees for verifying claims over and above the professional fees is not in consonance with the sections of the code. Charging claim verification fees apart from professional fees increases the CIRP cost and thereby burdens the debt-ridden corporate debtor further with additional cost. In this contravention, the IP has submitted in his response that the fee for verification of claim was not a fee separately charged by the IRP for verification of claims apart from his professional fees. The costs incurred are in nature of office expenses. It is not imperative on the IRP or the RP to incur office expenses of several types out of the professional fees charged by him. However, the same was also put forward COC for its approval, but it was rejected. In this, the disciplinary committee finds that the COC had already approved a consolidated fee of IRP for performing the functions entrusted upon him under the code, including verification of claims. Therefore, the DC is of the view that the IP has wrongly presented to the COC an additional expense of verification of claim, which is his inherent duty as an IRP. Our next contravention in this matter is delay in filing report certifying for constitution of COC. The board observed that there was a delay of 8 days in conducting the first COC meeting, which had violated the CIRP regulations. In this, the IP submitted that due to voluminous and unorganized documents, which led to delay in certifying constitution of COC, therefore the IP pleads that the delay was not due to failure in discharge of his duty as an IRP. Rather, he wanted to get the documents and clarifications from maximum number of home buyers so that they may be included in COC. This was accepted by the disciplinary committee. Our next contravention is delay in conducting the first COC meeting. In this present matter, there was delay of 8 days in conducting the first COC meeting. In this, IP submitted that the delay in constitution of COC was caused due to delay in verification. The IP had also filed a separate application to AA for appointment of authorized representative of the home buyers, which was heard and allowed thereafter. Due to delay in communication of order, there was also a delay in issuing the notice of first meeting of the COC and conducting the same. In this, the DC has held that considering the quantum of delay is not substantial, the DC is inclined to take a lenient view in this matter. In this, the order passed by the disciplinary committee is that the DC, in exercise of powers conferred by, hereby wants IP to be extremely careful and diligent in performance of his duties under the code, and also directs him to deposit an amount of 1,87,000 in the account of CD. This is pertaining to the first contravention, if the same has been already paid by the IP from the accounts of CD within 45 days from the issuance of this order. In the next matter, the contravention here is constitution of COC without verification of claims. COC was formed without verification of claims of the financial creditors. Further, the financial creditors were admitted into the COC based on the confirmation of debt letter of the corporate debtor and not based on the verification of books of accounts of the corporate debtor. In this, the IP submitted that he had duly verified the claims of the creditors with their ledger accounts maintained in the books of the corporate debtor and the audited balance sheets of the corporate debtor. The DC observed that various contractual documents pertaining to such claims were available with the IP, but the same have been not taken into account of verification of claims. Thus, the IP has failed to verify the claims of the creditors with corroborating documents. Hence, the constitution of COC without verification of claims is per se against the provisions of the code. Our next contravention is non-compliance of the adjudicating authority's order for submission of proof of claims of the COC members. AA has directed the IP to produce sufficient proof of debts, but this order was not complied for 9 months. The IP had merely sent the details by email to the registry of the AA instead of properly filing it with the registry. In this, the IP submitted that he has duly complied with the order by filing the same in a zip file with the registry of the AA by email along with physical copies. However, the DC finds that when the documents filed by the IP did not reach the adjudicating authority, the IP should have taken up the matter with the registry so that the documents filed by him could have been placed before the adjudicating authority, and observation of non-compliance by AA in this regard could have been avoided. Our next contravention is inclusion of related parties of corporate debtor into COC. It is observed that the IP has constituted the COC with various related parties of the corporate debtor and unjustifiably assigned voting rights in violation of the provisions of the code. In this, the IP has submitted that as per his understanding, Section 21 of IBC does not bar members of the COC from being interrelated with each other as long as there is no relation to the corporate debtor. Further, there is no bar in the PRA being related to the members of the COC as long as the PRA is not related to the corporate debtor. In this, the DC holds the contravention and finds that various members of the COC are related parties of the corporate debtor and have been unduly assigned voting rights. Furthermore, the DC also observed that the SRA is also ineligible as per Section 29E of the Code to submit the resolution plan being related party of the corporate debtor. Further, the IP had conducted this resolution process in gross violation of his fiduciary duties entrusted upon him under the code. Our next contravention is signing affidavit under Section 29A on behalf of the resolution applicant. The board observed that the IP had affixed his signature on an affidavit under Section 29A, which was required to be submitted by the authorized representative of the SRA. Further, despite SRA being a related party, the IP submitted a compliance certificate in their favor, finding them eligible to submit a resolution plan. In this, the IP submits that the SRA had sent him an unsigned and not notarized print of affidavit for approval, which inadvertently was filed before the adjudicating authority. He further stated that he had no malified intention and had only mistakenly signed due to inadvertence. There was also a properly signed 29A affidavit, which was duly signed by the SRA. In this, the DC finds that it is the duty of RP to submit such records before the adjudicating authority. Having paramount importance of such affidavit under the code, the submission of IP that it was signed mistakenly due to inadvertence cannot be accepted. It becomes more grave as the SRA was not eligible under Section 29A as observed above. Hence, the DC finds that the IP has contravened the provisions under the code. Our next contravention is failure to obtain claim from workers of the corporate debtor. The IP, despite being aware of the substantial claim of the workers of the corporate debtor and ongoing proceedings before the Honorable High Court, the IP failed to consider the same and did not advise the workers of the corporate debtor to file claims with him. Further, no provision was made for statutory claims in the resolution plan. This subsequently led to quashing of the resolution plan by the Honorable NCLAT as interests of all the stakeholders were not taken into consideration. In this matter, the IP submitted that the claim of the workers' union was not accepted by the corporate debtor and is not reflected in the audited balance sheet of the corporate debtor. He could not have suo motu included any debt of the workers, and more so in the absence of any claim having been filed by the workers. It is reiterated that he had discharged his duty as RP of the corporate debtor in accordance with the statutory provisions with full honesty and objectivity and without any bias. However, the DC noted the submission of IP and observes that the IP was fully aware about the long pendency of the workman dues and their continuous efforts for its payment before various forums. However, the IP has shown a casual approach with regards to workman dues, particularly the statutory claims, including the PF dues and the gratuity dues. In this matter, the disciplinary committee has cancelled the registration of the insolvency professional. In the next matter, the first contravention is failure to conduct required due diligence of the resolution plan. The board observed that the IP had appointed a valuer for conducting third valuation of assets of the corporate debtor on behalf of the COC, wherein the costs would be borne by the COC itself. The liquidation value of the third valuation report was much less than the previous two reports. It was also the duty of the RP to ensure that the resolution plans submitted are in accordance with the law. However, by allowing the liquidation value of the third valuation conducted by COC at its own expense as the basis for distribution of planned amount among the stakeholders, the IP has acted in violation of code. In this, the IP has submitted that the COC, in its commercial wisdom, decided to conduct the valuation. The IP had also submitted a due diligence report. After receiving the final resolution plan, he forwarded the same to the COC. From this point onwards, the IP has no role to play in scrutiny of the resolution plan. In this, the DC finds that it is apparent that the third valuation was done at the behest of the COC, even though there was no need for third valuation, as there was no disparity between the earlier two valuations. It does not seem to have affected the distribution under the resolution plan. In this, the disciplinary held that if there was any factual discrepancy for the purpose of distribution of amount of resolution plan, the IP should have filed an application before Honorable NCLAT for due rectification. In this matter, the DC thus disposes of the show cause notice with caution to IP to be more careful next time. In our next matter, our first contravention is non-filing of extension application. In this matter, the board observed that an application for seeking further extension of liquidation period was filed after almost 6 months, that is a delay of 182 days, that too without any application for condonation of delay. The IP had failed to file an application for extension of liquidation period prior to the expiry of the approved extended period. In this, the IP submits that he had provided necessary application to his advocate for such extension of liquidation period. However, it was missed by his advocate to do the same within time. Thereafter, he approached another advocate to file the said extension application, which was heard and allowed by the adjudicating authority. The IP further submitted that due to this delay, nothing was materially affected as the financial creditors had decided to initiate action under Section 52 of the Code and realize the properties of the personal and corporate guarantors as there was no asset with the corporate debtor to liquidate. In this, the DC finds that the submissions have no substance as the liquidator failed to follow up with his advocate. Said delay of 182 days is gross negligence on the part of the liquidator and dereliction of the duty assigned under the code and the regulations. Our next contravention is handling too many assignments. As per clause 22 of the code, the IP must refrain from accepting too many assignments. The IP herein has been handling 17 assignments which are beyond his capacity. To this, the IP submitted that he is the first person to get enrolled as an IP. Due to early bird criteria, he was allotted 4 cases within 9 months, and there were few assignments wherein he was appointed as IRP but did not continue as RP or liquidator. Further, because of few successful assignments, few banks repeatedly gave him more assignments considering he has manpower of more than 25 people. Findings of TC in this is that the code strictly states that the IP should refrain from accepting too many assignments. The IP has been unable to devote adequate time to each of his assignments, due to which there was also a delay in filing extension application. In this matter, the DC has suspended the registration of the IP for a period of 1 year. Our next matter, the first contravention herein is issues regarding admission of claim and reconstitution of COC. The IP had received a claim from an operational creditor, which was rejected by the COC when it was put for voting, considering its inclusion in COC. However, the IP had admitted a claim of said operational creditor, but he did not reconstitute the COC under the regulation. Seeking approval of COC regarding claim of an operational creditor is unwarranted and in nature of surrendering the independence of IP to COC. In this, the IP has submitted that his conduct in the matter of reconstitution of COC was done by mistake and it was unintentional. to which the DC finds that there was a duty of IP to reconstitute the COC upon admission of claim. Further, in the present case, the financial creditors were related parties. Hence, the CIP regulation mandates setting up COC with operational creditors. Our next contravention is failure in filing avoidance application. The IP had identified a preferential transaction and sought permission of COC for filing such avoidance application, wherein a resolution with 80.46% was passed in favor. It was admitted by IP that the decision was put on hold as COC members were intending to settle the dues and consequently to withdraw from CIRP. The CIRP regulation does not mandate IP to seek approval from COC for filing of such avoidance application. In this, the IP submitted that the suspended directors and COC members were making settlement for outstanding dues. Further, because the timeline prescribed by the code to file the avoidance application had already passed. The findings of DC in this matter are that there are duties enshrined under the code and regulations upon IP which are crucial in nature, and one such is filing avoidance application. The filing of such application cannot be withheld on the grounds of settlement. Our next contravention is delay in filing of application for extension of CIRP and filing of forms beyond prescribed timelines. The COC wherein resolution for extension was passed was held after completion of 180 days of the CIRP period. Hence, the extension application was filed thereafter, which contravenes Section 12 of the Code. There was substantial delay in filing CRP 6 as well. In this, the submission of the IP was that the adjudicating authority had granted extension of CIRP irrespective of the delay. He also submitted that the CRP forms were also submitted with respective delay fees paid. In this, the findings of the DC are the delay on the part of IP cannot be accepted. IP should be careful in filing applications and forms within timelines prescribed. Our next contravention is violation of board circular dated Jan 16, 2018. Said circular provides for disclosures by IPs and other professionals appointed by IPs. In the present case, a legal counsel was appointed and approved by COC. However, while filing applications before the adjudicating authority, no disclosure was filed as mandated under the circular. In this, the IP has submitted that the appointment of said legal counsel was not intimated as per the circular. The DC finds that the IP had not filed relevant disclosures as are mandatory, and thus contravention on this ground is held. Our next contravention is appointment of ineligible auditor. As per the regulations, the liquidator shall not engage a professional who is his relative, is a related party of the corporate person, or has served as an auditor to corporate person at any time during the 5 years preceding the liquidation commencement date. It is evident that the CA firm appointed were ineligible as the said CA firm was the auditor of the company during the 5 preceding years. In this, the IP submitted that the IP considered the existing auditor being as per the Companies Act, the statutory auditors are independent to corporate person. Further, he submitted that the said violation was not intentional. In this, the DC finds that such appointment is in contravention of the regulations. Our next contravention is non-submission of preliminary report. The liquidator failed to provide preliminary report as required under Regulation 9 of Voluntary Regulations 2017. In this, the IP submitted that the preliminary report of the corporate debtor was sent through email, but this email could not be retrieved from the sent box of the liquidator. In this, the DC finds that the conduct of the IP has been quite negligent in discharging his duties under the code. In this matter, the IP's registration has been suspended for a year. We have two latest amendments under Insolvency and Bankruptcy Board of India, Insolvency Resolution Process for Corporate Persons, Amendment Regulations 2023, and Insolvency and Bankruptcy Board of India, Insolvency Professionals, Amendment Regulations 2023. The first amendment is under Regulation 31, Clause A, Subclause Regulation 1, wherein For removal of doubts, it is hereby clarified that the regulatory fee under this sub-regulation shall not be payable in cases where the approved resolution plan in respect of insolvency resolution of a real estate project is from an association or group of allottees in such real estate project. Our next amendment is under Regulation 5, talking about the qualification experience in Clause C of Regulation 5, Subclause 2. Over here, successfully completed the graduate insolvency program as may be approved by the board. The word post has been added before the graduate insolvency.
Post-graduation added.
Yes.
Another course, so they will add new course now. Yeah. Yes.
Yes. We have covered all the orders.
Okay, thank you.
No
I-
problem.
If anything, anyone want to discuss, or we can close this session because we have covered the amendment, recent amendment, disciplinary actions, policies, and important judgments. Anyone else, or we can close this webinar? I think we can. Mr. Devang, you want to say something? You are on mute. You are on still mute, Mr. Devang. Mr. Devang, you are still on a mute.
Yeah, it was excellent. The long points in the case laws and other things which are long and in depth and other things is very lucidly explained, and the summary was excellent, you can say.
Yeah, thank you. Thanks, participants. Thanks, Kantani, for presentation. I request participants keep on attending and give your suggestion if anything you want. Thanks a lot. Thank you. Thanks, everyone.
No questions means it's a good thing, presentation.
Acha, just reading all cases is monotonous for you. Some deliberation will be good, just my view, but it's okay. Thanks. Surely,
But it was very made in very short and to the point.
thank you. Thank you.
Yeah, welcome. Thank you.
Thank you, everyone.
Thank you.